Welcome to Immigration Quicktake. This is Ellie Rutledge with the American Immigration Lawyers Association. Yesterday, the Fifth Circuit Court of Appeals refused to lift an emergency stay on President Obama's executive actions. Here to explain the decision and consequences is Melissa Crow, Legal Director at the American Immigration Council. Melissa, thanks for joining me. What did yesterday's decision say?
We were disappointed, but certainly not surprised by yesterday's decision, given the composition of the panel. 2 out of the 3 judges found that a stay of Judge Hanen's preliminary injunction in this case was not warranted, and their primary rationale was based on the extra expenditure that Texas would be required to make to issue driver's licenses to the beneficiaries of the expanded DACA and DAPA programs. While the court, or the 2-judge majority of the court rather, noted that acts within the discretion of the agency are not normally subject to judicial review, they looked to the fact that very few DACA applications have been denied in an exercise of discretion to allegedly demonstrate that discretion is not at play or would not be at play in this context as well. In fact, the small number of DACA denials stems, I think, more from the fact that the community that came forward to apply for DACA was self-selecting, and people didn't want to bring themselves to the notice of the U.S. government if they weren't pretty sure that they were eligible for the benefit under that program because they were afraid that they might be deported if they didn't receive DACA. So I think that's in some ways a red herring. The dissenting opinion in this case by Judge Higginson I think was a lot more well-reasoned, and Judge Higginson reminded us that executive action, and particularly the authority to decide on priorities for immigration enforcement, has been well established for many years, both inside the immigration arena and more broadly. And Judge Higginson pointed to the prior decision in 1997 of the Fifth Circuit in another case called Texas versus U.S., as well as the Fifth Circuit's recent decision in the Crane case, which reaffirmed the validity of the DACA program. Finally, the court cited the Supreme Court's decision in Arizona versus U.S., which made the same point as well.
Thanks, Melissa. Does this decision have any impact on the underlying lawsuit?
I think it's important to remember that there are actually 3 levels at which this case is currently proceeding. This decision is about the U.S. government's request for an emergency stay of the preliminary injunction, the block, on the new deferred action initiatives announced by the president. The argument on the merits of the preliminary injunction is scheduled to take place in early July. So in a sense, we have another bite at the apple of getting the preliminary injunction lifted. And then, of course, we still have the merits of the decision, which will unfold in front of Judge Hanen once these preliminary matters have been addressed.
What do you expect to see happen next?
Well, I think the first thing that we're going to see, sadly, is that families and individuals who have been waiting so long to normalize their presence in the United States are going to have to wait even longer. They're going to have to remain underground, and the uncertainty and the anxiety that goes with the possibility of being deported at any time is going to continue for the foreseeable future, at least. In terms of next steps in the case, we hope that the U.S. government will act promptly to address this ruling, which we think is inherently flawed. It's possible that they could take it up to the Supreme Court immediately, and many groups have advocated that. And it's also possible that they could engage in notice and comment rulemaking on the deferred action initiatives. In this case, which is a matter of policy and a matter of agency discretion, The Administrative Procedure Act dictates that notice and comment rulemaking is not in fact warranted, but it would be a very easy way out of this situation. It could have unfortunate consequences down the line by establishing a precedent of having to do notice and comment rulemaking in this kind of a situation. But that's another option of what we might see. And the third option, I think, is that the government will just wait to see how the argument on the merits of the preliminary injunction goes in early July. And I believe it's currently scheduled for the week of July 6th.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.